These are the 6 milestones of the property sale process. When first establishing a relationship with a client, it is important that both the principal and agent are aware of the responsibilities and rights each other have with one another. As an agent, you must provide the vendor client with a copy of the agency agreement guide. This must be done before signing an agency agreement. Set up and sign an agency agreement, which includes conditions and an estimated value of the commission payable, when the agency agreement ends, and how the property will be marketed. You must provide the client with an opportunity to seek legal advice before signing the agency agreement, and standard agency clauses are available on the REAA website. Obtain a copy of the certificate of title for the property. This is required to verify all information on the tenure, ownership, and legal. Obtain all information on interests and restrictions of the property. This includes covenants, caveats, and easements. All of these are required to be brought to the attention of the potential purchaser. You must inform the vendor client about all information. Recommend an information pack be obtained by the vendor's lawyers. This may be organised by yourself, the agent, or given authority from the client. You must inform the client this will incur legal costs. Under obtaining a copy of the certificate of title for property, this relates to the second case summary of Mr. Shaw, who misrepresented the property size to a complainant purchaser. It is the responsibility of a new agent to familiarise themselves with key statutory and regulatory requirements of the standard sale process to avoid breaches such unsatisfactory conduct present in the case summary of licensee Mr. Shaw.
Receiving offers from potential purchasers. Sales by negotiation. A potential purchaser has their offer by completing the commercial terms in a sale and purchase agreement. Sale by negotiation. All auction terms and conditions are provided prior to the auction happens. The auction starts when the auctioneer offers the first bid to the potential buyers. Once a bid is made, it is not final. They are able to withdraw at any time until the hammer goes down. Sales by tender. Potential purchasers will submit a document detailing their offer for the property. The vendor, analysing their best option, can then consider these offers. Terms of the tender will be provided before the offers are able to be made. Conflicts of interest. If you, the agent, or anyone connected with you wishes to purchase the property, written consent must be obtained from the client and an independent valuation obtained. These people may be your business partner, employee, family, or a company connected to you, the agent. The client may choose whether to give or deny consent to purchase the property in an event of a conflict. Further information on selling to an agent or a person connected to them can be found here. Entry into an agreement for sale and purchase with a selected purchaser. According to Section 9.7 of the Real Estate Agents Act 2012, before a prospective client, existing client, or customer signs an agency agreement, a sale or purchase agreement, or other contractual document, a licensee must recommend that the person seeks legal advice, ensure that the person is aware that they can seek other advice and information, allow that person a reasonable opportunity to take advice.
A deposit is not required in New Zealand, however 10% of the purchase price is usually what happens. The deposit is part payment of the purchase price and it is an earnest, which means that if the buyer does not choose to go through with the purchase, the vendor will keep the deposit. The agent as a stakeholder. The contract must be completely unconditional before the agent gets their commission fee. Deposit must be held for 10 working days according to Section 123 of the REAA 2008. They must repay the deposit to whoever is lawfully entitled to it. And as previously stated, all commission conditions and amount must be disclosed in the agency contract in order to be payable to the agent. Settlement day is when the purchaser pays the rest of the money for the house. It is smart if the owner moves out of the house prior to the date. It is important that before the settlement date, all the paperwork has been completed in terms of ownership. This means that all the chattels as agreed upon should be moved or stayed in the house. A settlement sale must be given to the new owner, and if late possession occurs, covered in Section 3.11, the purchaser shall pay interest on top of what is already owed.